My name is Carl Pearson. I'm an attorney defending against foreclosures, and part of the defenses I provide include suing banks for wrongful foreclosure and suing to obtain a loan modification agreement for homeowners. In this video, number 50 of mine, I'm going to discuss the proposed settlement agreement dated March 3, 2011, offered by the 50 state attorneys general to the 5 main banks having fraudulent foreclosure problems. There is some disagreement among the 50 state attorneys general, some believing the proposal has gone too far, such as by requiring a reduction of the principal amount of the mortgage, and note, in appropriate cases. The agreement is 27 pages long and would provide very little relief to homeowners if signed by the 5 banks. And I will go into that a little bit. But the banks include the Bank of America, JPMorganChase, Wells Fargo, Citigroup Inc., and Ally Financial Inc., previously known as GMAC. And these 5 banks have 59% of the U.S. market for loans. Now, let me tell you about the highlights of this 27-page proposed agreement and what this means to homeowners in different stages of foreclosure. It means a lot more to some than to others. Now, you can read it for yourself on my website at carlperson.com/agreement.php, all lowercase. That's carlperson.com/agreement.php. Now, here are the highlights of the proposed settlement agreement. It's first of all dated March 3, 2011, and it's just been submitted to the 50 states, by the 50 state attorneys general, and there is some disagreement among them. Possibly as many as 12 of the attorneys general don't agree with the document, the proposal in its entirety. But to just look at some of the highlights, in any pending judicial foreclosure proceeding prior to confirmation of sale or in a bankruptcy court proceeding, the servicer shall notify the borrower in writing if the servicer has knowledge that any filing or document presented in court, including any affidavit, sworn statement, or proof of claim, contained inaccurate information, or that state laws or regulations may have been violated during the preparation, signing, notarization, or filing of the document. Servicers shall wait 30 days after notifying borrower before proceeding in court. Now, that's a staggering paragraph, and I doubt seriously if the banks are going to agree to that, because here they have a requirement of disclosing any weakness in any infirmity in their case. It would be great if they had to disclose this in a pending judicial proceeding. So that means an existing judicial proceeding or one in the future. So that's a very powerful provision. Also, paragraph 16 at page 3, the servicer shall be required at the servicer's expense to take appropriate action consistent with state law and court procedure to correct robo-signed or other improper filings or documents presented in a judicial foreclosure proceeding or bankruptcy, including affidavits, sworn statements, and proofs of claim, and by withdrawing, if appropriate, and resubmitting such filings or documents, or as to a foreclosure case, dismissing the case where such affidavits were submitted. So that's staggering, actually, for existing cases, if in fact that provision is going to be adopted by the banks, if they will agree to it. Because I took time to read these, I'm going to cut out a few. The servicer shall take appropriate action to promptly remediate any inaccuracies in the borrower's account information. So we've had a lot of problems where people say that the banks haven't given full credit for payments, and now they would have to promptly remediate any inaccuracies that are brought to their attention. And interestingly enough, in page 6, documentation of note, holder status, and chain of assignment, the servicer shall set forth in a pleading that the foreclosing party has the right to foreclose, and it shall attach a copy of the note with all required endorsements. And in the same manner as in that paragraph I just read, the servicer shall also identify the holder, custodian, and location of the original note, mortgage, and any interim assignments and or allonges, which are additions to the note to add space where they can assign the note to other people. That's called an allonge. And the servicer shall indemnify all custodians or recording systems used to identify the holder of the note and assignments of the mortgage or deed of trust. So that's a powerful provision. Of course, we still don't know if merely by attaching a copy of the note that the note in fact is where they say it is. So we would need discovery still to prove that they are correct in their assertions. Paragraph 3 on page 7, if the original note or any interim assignment or allonge is lost or otherwise unavailable, the servicer shall comply with applicable law in any attempt to establish ownership of the note and the right to enforcement. In addition, the servicer shall recite the good faith efforts it has made to obtain or locate the note or interim assignments or allonges. So this is all part of that problem where the banks or the servicing company can't find the note. The servicer shall be prohibited from intentionally destroying or disposing of the original note or other like documents. That's an interesting, useful paragraph. And if requested by a borrower at any time, the servicer shall identify the trust or other entity in which the borrower's loan is held and provide contact information for each such entity. Now, as to MERS, the Mortgage Electronic Registration System, this agreement says that issues relating to MERS are reserved for further discussion. In other words, it was such a hotbed and so complicated that they didn't even bother to deal with it in this 27-page proposed agreement. It is so complicated. More than half the mortgages in America are registered with MERS, so that in itself would probably take another agreement at least as long as this proposed agreement. Then on page 8 it says that the servicer shall track any instance where an adversary requests the imposition of sanctions against a law firm, foreclosure firm, trustee, or other third-party provider, or where the court imposes such sanctions, and shall take appropriate action, including termination of its relationship with any third-party provider that has been sanctioned by a court on multiple occasions. This is going to make the law firms for the banks very careful about what they do to avoid getting sanctioned, because multiple sanctions will cause them to lose their business. The servicer shall adopt and provide to third-party providers escalation procedures to allow attorneys and other third-party providers to communicate directly with the servicer. At this point, I am not allowed to contact the servicer because the servicer is not a law firm representing the bank. It is the bank, and it represents the bank. It's not an attorney, and therefore attorneys for the borrower aren't allowed to contact them, and only the borrower is, and therefore the contact becomes ineffective when the borrower tries to do it. The attorney is perhaps a better person to do it, and this would legalize that presently prohibited relationship, communication. Now, loss mitigation requirements, beginning at page 9, the servicer shall offer and facilitate loan modifications rather than initiate foreclosure when such loan modifications result in a greater net present value, NPV, net present value, than foreclosure. And the NPV formula used by the servicer shall be made available to the organization that regulates this agreement upon request. If a borrower requests a modification and the servicer believes that a pooling and servicing agreement prohibits modification, the servicer shall nevertheless perform the appropriate NPV test. And if it is positive, the servicer shall send the NPV test results to the trustee or any other parties authorized under the terms of the agreement in order to obtain the necessary consent, allowing servicers to offer the modification. As it is now, when the servicer brings suit, they don't have the right, in many cases or most cases, to modify the agreement, the loan agreement. So when they bring suit, they can't settle the case, and that to me means that the proper parties aren't there. This is taking that into account and saying that if this occurs, they have to go back and get the agreement from the trustee of the pooled mortgages in order to be able to settle the case by reducing the principal and or reducing the interest rate. Now, on page 9, for all borrowers enrolled in a trial period plan under prior HAP guidelines, where the borrowers were not pre-qualified and who made all required trial period payments but were later denied a permanent modification, the servicer shall suspend any foreclosure-related activity, including the filing of a motion for relief from stay in a bankruptcy proceeding, and re-evaluate such borrowers for a HAP or proprietary, that is a non-HAP loan modification using current financial information. All borrowers enrolled in a trial period plan under current HAP guidelines or similar proprietary programs and who have made 3 timely trial period payments shall immediately be converted by the servicer to a permanent modification under the applicable program guidelines, absent fraud in the application. The dual track is prohibited. You can't both have a loan modification working and be in a foreclosure situation as well, which has been a major evil, where they have encouraged people, required them to go into default and seek a loan modification agreement, which the banks never intended to give, and they then have set them up for foreclosure, which the bank pursues. That now is prohibited under this agreement. And if the borrower has substantially completed an application for loan mitigation, they can't proceed against them to try to take away the property. There's a single point of contact being set up under this agreement, so there's just one person that you need contact about your loan. This way you won't have that current problem of not being able to find somebody who knows what your loan is about. They shall provide information about why you don't qualify, very specific information about what guidelines were used when evaluating your loan, and they have to disclose that to you. The specific reasons for the denial, the calculations made, and the factual information used, including but not limited to the disclosure of property value and the discount rate. So that's an important thing to know, how they dealt with your loan, and they have to deal with loans equally. They have to have a standard that applies to all. They have to develop a loan portal so that various people interested in the information can, including the bankruptcy court, can find your information readily. There's an independent review of loss mitigation denials, so that even if the bank doesn't accept your efforts to mitigate, even including a short sale or a loan modification agreement, there are provisions for independent review of that. And as general loss mitigation requirements, the servicer shall maintain an adequate staff and system for tracking borrower documents and information that are relevant to foreclosure, loss mitigation, bankruptcy, and other servicer operations. The servicer's employees, and this is very important, shall not instruct, advise, or recommend that borrowers go into default in order to qualify for loan mitigation relief. That they have been doing in spades up to now, and are still doing probably. The servicer shall standardize the input for the NPV analysis, at least to the extent required by HAMP, so that everyone's treated equally. The servicer shall design proprietary loan modifications that are sustainable, and shall offer rate reductions for at least 5 years, and shall not exceed comparable HAMP rate adjustment standards. No balloon payment requirements until the end of a loan payment period. The principal reduction loan modifications, and it needs further discussion, so that they haven't really dealt with this fully, but there's going to be more information about that. So that's a critical point, of course, in all of this, is to have a reduction in the principal amount. And there would be a requirement that the second mortgage be reduced appropriately in proportion. The servicer shall consider appropriate monetary incentives to underwater borrowers to facilitate short sale options. If there's a transfer of a servicing agent, they have to notify the new one about any existing loan modification applications, and the new one has to come in and work with that. And any successor shall agree to the loss mitigation requirements of this particular agreement. If they come in, they have to agree to that, to abide by it. The servicer shall not assess any fees for default while a completed loan modification application is under consideration or being performed as a trial modification. And we're getting down to the end now. They can't force place insurance. There's standards now for forcing you to take insurance. And the servicer shall have a general duty, this is very important, a general duty of good faith and fair dealing in its communications, transactions, and course of dealing with each borrower in connection with the servicing of the borrower's mortgage loan. Very important provision. We believe that that's in the law right now, and they're reinforcing it by putting it in here. Also, page 26, the servicer shall provide monetary relief as compensation or penalties for unlawful conduct to settle claims owed to the government and or to fund programs to help homeowners avoid foreclosure, including support of nonprofit housing counseling, legal aid assistance, hotlines, portal access, borrower education outreach, mediation, post-foreclosure relocation assistance, and similar efforts. And the servicer shall establish a fund and a process to compensate borrowers who have been victims of servicer misconduct. There's third-party monitoring of this agreement. A material violation of this agreement constitutes an unfair and deceptive trade practice and a breach of the duty of good faith and fair dealing. So let me just review basically what all of this means as a lawyer, having all of that if it were implemented by agreement. It basically is a national statute implemented by agreement among the major banks with each of the attorneys general representing the states. So it's a federal law in a sense. It's a unique situation where the states have gotten together and are creating in effect a comprehensive uniform federal statute basically by agreement to regulate the foreclosures. It's a very substantial document. If it goes through, there's a lot of changes to be made. Whether it goes through or not, of course, is another story. But I said at the beginning that you can't really count on this thing going through. But if it does go through, there are obviously, it is a major development for homeowners. But it requires litigation to implement, because they may have a duty, but there's a breach of duty all the time here. I mean, they're always breaching their duty. And you need an attorney to pursue your claims. You will have claims of wrongful foreclosure. You'll have claims for injury over here, punitive damages even. You'll have a lot of things that you need an attorney to handle this, and this is especially for those who have lost their homes already. There's coverage for you within the confines of this, but even without this, the doctrine of wrongful foreclosure allows you to get recovery, even without this agreement. With this agreement, it's stronger, but it isn't agreed to yet, and it may not ever be. It may be too good. But anyway, that's my take on it, and I hope that you paid attention to it, because it's a very important concept. It covers most of the problems that we have right now in the foreclosure market, and it is an attempt by the states to deal with it, because the congressmen are not going to deal with it. It's too politically, they can't do it because they would lose their campaign contributions. So if you have any questions, please give me a call. My phone number is 212-307-4444.